If you have ever heard someone say, "I am coming to the US on a founder visa," I need you to pause right there. Because in US immigration law, there is no single visa called a founder visa. And that one misunderstanding is responsible for a lot of wasted time and bad planning. Here is what you will know by the end of this video. 1. The real visa categories founders actually use. 2. Who is affected. And 3. A practical strategy. Immigration for founders is not just about picking a visa. It is about picking the right order of moves: company structure, fundraising, payroll, and travel. When people say founder visa, they usually mean one of three things: a path to live and work, a way to bring a team, or a long-term plan for a green card. Now, before we go into visa types, we need 3 questions answered. 1. Where are you? 2. What is your status? 3. What is your startup reality today? This is where people get denied. They pick a visa because it sounds right, not because their evidence matches the legal requirements. Myth: if I incorporate a US company, I automatically get a visa. Reality: incorporating a company does not give you any immigration status. Another myth: if I am a founder, immigration will treat me like a special category. Reality: you are still an employee in the legal sense. Now let us talk about the H-1B specialty occupation visa. Founders use it, but the government wants to see an employer-employee relationship. Someone has to be able to fire you. If your startup cannot pay a realistic salary yet, H-1B can be hard. Also, remember the H-1B cap and lottery dynamics. Timing and selection risk matter. Next, O-1. This is for individuals with extraordinary ability. It is appealing because it is not capped, but you must prove a record of distinction and acclaim. Myth: if I raised money, I automatically qualify for O-1. Reality: fundraising helps, but you need a broader package of traction and recognition. The E-2 Treaty Investor Visa is a big option for citizens of certain countries. You invest a substantial amount, but remember, E-2 is not automatically a path to a green card. L-1 is for intra-company transferees. It works if you have an overseas company and are opening a US office. You need a real plan to build a real operation. Many founders begin on OPT, but the work must be related to your degree, and STEM OPT has specific employer compliance rules and oversight. Myth: if I am not paying myself, it is not work. Reality: immigration considers unpaid productive labor as work. Be careful before doing day-to-day operations. The strongest green card cases are built over time. Evidence of impact, letters, media, and revenue. Do not wait until your status is about to expire to plan. If you are building a US startup, here is a do this. Avoid this checklist you can literally save and use. Do this. Write down your exact expiration dates. Avoid this. Making major business promises before you know your work authorization timeline. Do this. Build a document folder now. Incorporation docs, cap table, board agreements, and payroll plans. Avoid waiting until a crisis to find them. Do this. Plan for travel. Ask what happens if you leave next month. Avoid booking international travel during sensitive filing windows without confirmation. Do this. Verify everything against primary sources like USCIS and the Department of State. Avoid viral posts that say a visa is guaranteed. Nothing is guaranteed. Let us recap. There is no founder visa. Use existing categories. Location and status drive the strategy. And the safest approach is a clear, fact-based plan. Do not panic. Most founders have a path. Tell me your situation in the comments, subscribe, and let us decode startup immigration together.